just have one person standard, okay?
Just watch it. One for this first. My name is Malik. Case number 66. 346 over 21. You watch it. When the last time.
Purpose of Nigeria. Pastor Teddy, Naruswa Bugingo, who was a lawyer on watching brief, who stands with us. The accused persons have appeared today for purposes of plea taking, issued criminal summons. This Honorable Court in the past sitting issued criminal summons which were served to the respective accused persons. And Your Honor, we filed in this court affidavit with proof of service of the same. We filed in this court affidavit with proof of service of the same. Before we proceed, Your Honor, we pray to tender an amended charge sheet. Your Honor, the amended charge sheet bears the same offenses. As the charge sheet that was in court before. Bears the same offenses as the charge sheet that was in court before. Save that.
1. A letter by DPP seeking to take over matter does not constitute a takeover. Does not constitute takeover. And this is buttressed by Article 120, Sub-Article 3, read as a whole. And Section 42, the MCA, also read as a whole. Secondly,
so in your submissions, what constitutes the takeover? So
What?
that they will know exactly
what constitutes the takeover is an appearance before the court by or on behalf of the DPP either preferably by formal application, but an appearance to demonstrate to court that the takeover complies with Article 120, Sub-Article 5 of the Constitution. Your Worship, Article 120, Sub-Article 5 states the exercising usual powers under this article, the DPP shall have regard to the public interest, the interest of determination of administration of justice, and the need to abuse of legal process.
the need.
The DPP shall have regard to the public
I
interest
did get the last part. The need
to
to.
prevent abuse of legal process. Those are the three parameters which the DPP must satisfy court that they exist. Then court, in exercise of its powers under Article 128, 1 and 2, the independent powers can make a determination that yes, in public interest, what is of justice, let the matter be taken over. Your Worship, allow me to refer you to Article 123A of the Constitution for comparison purposes. Article 123A, no, 3B, sorry, 3B, gives the DPP the function to institute criminal proceedings against any person or authority in any court. That is the function. But Your Worship, the power to charge final rests with court. The final decision to charge rests with court. That's why on every charge sheet there is a signature for a magistrate. So this court is the one to determine whether Article 125 has been complied with. Secondly, Your Worship, under Section 42 of the Magistrates Courts Act, private prosecutions are court-monitored proceedings. They are monitored by court itself. And specifically, Section 42.5 says, after satisfying him or herself that the case of the government has been disclosed and that the complaint is not frivolous or vexatious, the magistrate shall draw and sign a formal charge containing the statement of offenses or offenses and which have been committed. So, by the time of issuing summons, unlike in other cases by state, there is a prima facie case. There is a prima facie case already established by court. And Your Worship, that finding cannot be watered down by a DPP throwing it on file that now we have taken over from. Actually, Your Worship, they are reversing your finding. DPP is reversing your finding without any application before you. They are reversing the finding on prima facie case. And they are going ahead to reverse your charge sheet that they are amending it. This is not their charge sheet. This is a court charge sheet. I know these principles we should be discussing in the new school days, but these are constitutional-based principles. There could even be decisions, but these are constitutional-based principles which must be applied to protect the sanctity of the court. And the wider scope of usage of public powers. Your Worship, the DPP is a public body. So amidst whatever writings, what the position is that. So actually, let me refer you also to Article 28.1 and for the purpose of the Constitution. They require that fair hearing is non-derogatory. But here you are in a court of law. DPP is telling you I cannot be heard, but I have a right to be heard when I take over. Okay? Comes and says I took over. Taking over my case without hearing Your Worship. That's unconstitutional. It contravenes international law. So it is my prayer But again, lastly, that takeover is the subject of criminal application number 3 of 2022 in this court. It is under challenge. And I don't think it is proper for him to come here and say, having taken over. Your Worship, I pray that that charge sheet presented by the state be disregarded, since they, as of now, have no locus to address court. Since they are also on record, Your Worship, through Islam Ladam, showing no interest in this case. That is the very reason they ought to have filed the formal obligation. To demonstrate why they are making a U-turn now. Where is the interest coming from now? We didn't have to Islam Ladam at least to tell us why now. So, Your Worship, my prayer is that before all that is done, let court proceed with this charge sheet. When they are successful in their bid to take over after hearing, maybe they will bring the alternative charges that they wish them to. But they have no powers to amend or to substitute a court-drawn charge sheet. That's what I'm in the court of this court. I saw.
Persons take lead on the amended charge sheet that we have tendered before court. As it cures a few legal anomalies. Your Honor, in response to my brother, Article 120 of the Constitution of the Republic of Uganda creates the office of the DPP. Article 120 of the Constitution of the Republic of Uganda creates the office of the DPP and empowers the office of the DPP and empowers the office of the DPP to have control and management of all criminal proceedings. Control and management of all criminal proceedings. And Your Honor, that position has been settled severally through case law. That position has been settled severally through case law. But in particular, in exercising Article 120, Clause 5 of the Constitution, in exercising Article 120, Clause 5 of the Constitution, the DPP need not give reasons to anyone. The DPP need not give reasons to anybody. And without a doubt, the take-up of this matter is in public interest. In public interest and in the interest of the administration of criminal justice. And in the interest of the administration of criminal justice. Above all, it is in the interest to prevent abuse of legal process. Above all, it is in the interest to prevent abuse of legal process in the manner in which these proceedings should be administered. manner in which this proceeding should be administered. Article 120, Clause 6 of the Constitution, Article 120, Clause 6 of the Constitution states that in the exercise of the powers conferred on the DPP, in the exercise of the functions conferred on the DPP, is not subject to the direction or control. He or she is not subject to the direction or control of any person or authority. He or she is not subject to the direction or control of any person or authority. This includes the private prosecutor, and in particular for this case, my brother, Marema. Your Honor, in the case of Uganda versus IGP General Kaibula, in the case of Uganda versus IGP General Kaibula, criminal revision cause and others, General Kaibula and others, criminal revision cause number 34, criminal revision cause number 34 of 2016. From the last bit of page number 5 and number 6, but in particular, page number 6, the learned judge, Justice Joseph Murangira, stated that the letter that was written by the DPP expressing intentions to take over criminal proceedings was one of the procedures that the DPP can use in such instances. So, Your Honor, the position is the law is not cast in stone. The law is not cast in stone of the procedure that the DPP must adopt to take over. The law is not cast in stone of the procedure that the DPP can adopt to take over a private prosecution. In that particular paragraph, taking over can be by an ordinary letter. An ordinary letter. In page number 5, the previous page, it actually says it can take over even orally. And Your Honor, this function to take over is provided for under Article 120, Clause 3C of the Constitution. Clause 3C of the Constitution, where the DPP is mandated to take over and continue criminal proceedings. To take over and continue criminal proceedings instituted by any person or authority. Instituted by any person or authority. And such persons include Mr. I love calling him my brother, Marema Bilizi. You know, this is the same provision that is envisaged under Section 43 of the matter of the proceedings. At any stage, in fact, the DPP could have even taken over 1 minute after Mabili is filed At any stage, there is no need of consent of a private prosecutor for the DPP to exercise his or her powers of taking over and continuing private prosecutions. There is no need for consent of a private prosecutor. Your Honor, in the management of private prosecutions, in the proper management of private prosecutions, the DPP issued guidelines to the prosecutors. The DPP issued guidelines to the prosecutors, dated 2nd of March 2021. These guidelines are not necessarily law, but they are administrative frameworks. Under guideline number 3F, that there is no U-turn as alleged by my brother. There is no U-turn as alleged by my brother, Malema Lilies. As at the time when the prosecutor, my sister Ramla Damba, was asked, as at the time when the prosecutor, my sister Ramla Damba, was asked whether they intend to take over, she was not aware of any charge that had been signed by the magistrate. She was not aware of any charge that had been signed by the magistrate. Be accordingly dismissed. And I need to say something. The power to charge, like he said, the power to charge in light of private prosecution rests on the judicial officer. Rests on the judicial officer. But once a matter is taken over by the DPP, the officer preferring the charge can formulate the charge sheet at that stage. The officer preferring the charge can formulate the charge sheet at that stage. And Your Honor, the charge sheet that has been formulated is proper and the accused persons should take plea on it. Your Honor, my colleague Nahabwe, who is a counsel introduced later, has something brief we would like to also add.
As earlier introduced the Nahabwe Precious, what in brief for Counsel Robert Vitalo, and we would like to stress that we do not object to the charge sheet presented by my last brother. And we would like to state that upon receipt of the DPP's letter expressing interest, upon receipt of the DPP's letter expressing interest to take over our client's case, which was consolidated with the Babylon's case, we expressed his consent in writing. We expressed his consent to the takeover in writing in our letter dated the 17th January 2022. Having in mind the clear positions of the law and the powers of the DPP to take over private prosecution. Your Honor, we would like to stress that we are not party of any application. We are not party to any application challenging the DPP's takeover, and neither will we serve of any such. Also, we inform court that the first complainant has not presented any stay of proceedings, any order of stay of proceedings that we are proceeding in today. So we believe that the state has resources. Yes, has enough resources to take over this matter.
And also in light of the fact that America actually said they don't need the consent of anyone. So I think that should be the reason. Like maybe the Hawaii submissions are not relevant. Your 3 minutes are running. Please proceed.
Your Worship, first of all, Mr. Nahabu has made the case clear. For him, he's willing to work with them. With that submission, I state that since DPP has no monopoly over private prosecutions, then we can be co-prosecutors. We can be co-prosecutors.
Under what law? Under
Article 120. Because Article 123,
the specific provision under
Article 123 C talks about takeover and holding any criminal proceeding instituted by any other person or authority. So the article recognizes that any other person or authority can institute criminal proceedings. So there are about 3 people who can institute: the DPP, any other authority, or any other person. Now that DPP has 2 complainants who are cooperating with her, Mr. Rutaro, Mr. My case 66 can remain under me. We come here, we're going to prosecute as consolidated matters. Your Worship, in the case of Kaihura has to be distinguished. The issue there was formal application. The Chief Magistrate ordered for a formal application. The court did not say that DPP should not apply, but the point was formal application. But again, I refer us to paragraph 26 of the directive principles to the Constitution. They are called National Objectives and Directive Principles of State Policy. It is headed Accountability. XX V1, Accountability. says all public offices shall be held in trust for the people. That's paragraph 1. They are a public office. They are our trustees. They can't say they can't give reasons. 2, all persons placed in position of leadership and responsibility shall in their work be answerable to the people. So, lastly, this internal memo has no force of law. At best, it should be their evidence, but not to cite it to court that internal memo inside DPP's office says this. I request that this court don't rely on Makula because the facts are different. In any case, it's Victoria, and this court is not bound to follow Victoria decisions. I pray that the accused be charged under the original charge sheet, independence of hearing and determination of criminal application number 3 of 2022, challenging these actions. I so pray that.
In light of the summons,
authority or any person, the wording of the provisions of the MCA that the DPP can take over at any time should be translated and understood in the ordinary sense. Any time means any time before the conclusion of the proceedings. The case of Uganda versus IGP Kale Kaibura and others by Justice Mulangira is very, very directory in this subject. No specific procedure needs to be adopted by the DPP at any moment that the DPP wishes to take over criminal prosecution. As soon as the DPP picks interest, the expression to court to take over suffices. Also, once the DPP expresses that interest to take over and takes over, the charge sheet can be drawn up and the accused persons can answer to it. Also, under the law, a charge can be amended at any time, the primary consideration being that such amendment should not prejudice the accused or cause them injustice. In the instant case, I do not see the prejudice or injustice that the accused person suffer by answering to the amendment. It has already been shown that the amended charge is not in essence different from the earlier charge drafted by court, save for resident of Nachide village, Namayumba sub-county, officer district. N2, Susan Makula, Nantava, a female adult, resident of Nachide village, Namayumba sub-county, in Wachiso district. Are those your particulars? Are these your true particulars?
the village is Naked.
Naked. Thank you. So I'll read the counts of offenses and then each one will answer separately as applies to them. So count 1 is contracting a marriage by customary law when already married under the Marriage Act, Cap 251, Section 15. The particulars for you Pastor Aloysius are that on the 7th day of December 2021 at Kookie, Katabi Town Council, Wakiso District, having contracted a marriage under the Marriage Act, Cap 251, with Teddy Naluswa Bujingo, and during the continuance of that marriage, you did contract another marriage in accordance with the customary law with Susan Makula Nantaba. Do you understand what I have just read to you?
I've understood, but there's nothing true in it.
Is marriage with a person previously married, contrary to Section 42 of the Marriage Act, Cap 251. Susan Makula. Susan Makula Nantaba, on the 7th day of December 2021, at Kookie, Katabi Town Council, Wakiso District, being unmarried, you went through a ceremony of marriage with Pastor Aloysius Bugingo, a person you knew to be married to Teddy Naluswa Bugingo.
We are remaining with a few which can take about a fortnight. And also in line with the direction of this court, we expect to also receive more information and evidence from my brother Malema Bilizi. As court has notified him to avail us information, and also in light with our letter that we earlier submitted. So in light with that, I pray that the matter is adjourned for mention for a fortnight, and thereafter we fix the hearing date.
But the right to apply is pretty clear.
Your Honor, we have instructions.
Pastor, where?
Out of prayer ministry,
To Friday, 18th February 2022, for mention.
Most of